and I direct here at Notre Dame the Center for Citizenship and Constitutional Government. It's my pleasure, on the behalf of the National Association of Scholars, to welcome you to today's panel, 1857, Not a Citizen, the Dred Scott Case. We have a terrific panel for you today, and three of the nation's most thoughtful scholars. Let me tell you a little bit about the National Association of Scholars first. The NAS upholds the standards of liberal arts education that fosters intellectual freedom, the search for truth, and the promotion of virtuous citizenship. I'm a huge fan of NAS because they uphold what the university should be: reason, scholarship, civil debate in our colleges and universities, academic merit, academic rigor. The NAS expects all ideas to be judged on their merits, that scholars will engage in the disinterested pursuit of truth, and that colleges and universities will provide a fair and judicial and judicious examination of various contending views. So I'm proud to be a part of the National Association of Scholars, and very glad that you can join us for this terrific panel. Okay, we have three fantastic panelists. So let me introduce them in the order that they will speak. Let me mention too that there'll be time for Q&A after the panelists speak. You can use the Q&A function here on Zoom, and we'll ask questions for you if you write them through that function. Okay, so our panel is 1857, Not a Citizen, the Dred Scott Case. Dred Scott, as I'm sure almost everyone knows here, was a slave to a U.S. Army surgeon, John Emerson. In 1846, Scott sued for his freedom and that of his family, arguing that since he had been brought into a free state, he should be a free man. The case wound its way through the courts before landing in front of the Supreme Court and Chief Justice Taney. Just in an opinion by Justice Taney, the court ruled infamously that Black people were not included in the Constitution's definition of citizen. So we have a number of different questions to address. Among them are, what were the long-term effects or even the short-term effects of the Dred Scott decision? Did it contribute to the outbreak of the Civil War? If so, how? What was the view of the decision at the time by Americans in the North and in the South? Those are just some of the questions I expect our panelists will address. Okay, our first panelist is my good friend, Dr. Hadley Arkes. Hadley is the Edward N. Nee Professor of American Institutions, Emeritus at Amherst College, a senior fellow of the Claremont Institute, and the founding director of the James Wilson Institute. He's the author of some very important books, including Beyond the Constitution, Natural Rights and the Right to Choose, Constitutional Illusions and Anchoring Truths, The Touchstone of the Natural Law, and of course, his famous book, First Things. Professor Mark Graber. Mark Graber is the Jacob A. France Professor of Constitutionalism and Regents Professor at the University of Maryland. He's the author of numerous books, including A New Introduction to American Constitutionalism, co-editor of American Constitutionalism Structures and Powers, and American Constitutionalism, Rights and Powers. As someone who teaches undergraduate classes in constitutional law, I can say that the historical approach Dr. Graber takes is really excellent, and those are fantastic case books, especially for undergraduate use. And then David Tubbs. David is Associate Professor of Politics at the King's College, where he teaches political philosophy, constitutional law, and public policy. He's held fellowships at the American Enterprise Institute, the James Madison Program at Princeton University. He's the author of a really terrific book, Freedom's Orphan, Contemporary Liberalism and the Fate of American Children. So we'll give each panelist a few minutes to speak about our topic, and then we'll open it up to Q&A. Again, use the Q&A function via Zoom. Thanks for joining us. And Dr. Arkes, the floor is yours.
Okay, thanks so much, Phil, and to my friends at NAS, but it's really so good to see Mark and David again. I don't see them enough. As I was preparing this talk, it struck me that it would be, any discussion of this case would be pale if we didn't find some way of sounding those riveting remarks of Lincoln in that speech he gave in the aftermath of Dred Scott in June 1857, and find there again what Jack Bosson used to call the movement of Lincoln's mind. He fastened on Chief Justice Taney's remark or suggestion that the public estimate of the Negro is now far better than it was as the origin of the government, because everyone understood that Black people were a servile people, bearing no obligations, that bearing no rights that whites were obliged to respect. Now, Lincoln pointed out that in 5 of the original 13 states, Black people were voting, free Blacks were voting. But now, 2 of those states had rescinded the vote, and a third, Texas, was cutting back on it. And he said, and I'll just paraphrase until I quote, he said, in the beginning, we assumed that masters had unquestioned authority to emancipate their own slaves. But now there have been so many legislative restrictions put on the practice as to amount virtually to a prohibition. It used to be thought that states had an unquestioned authority to forbid or abolish slavery within their states, but it's become the fashion of late for constitutions to withhold that legislative power. It used to be thought that Congress had a plenary authority to govern territories of the United States and bar slavery from those territories, but now the Supreme Court says it may not, even if it would. And the Declaration of Independence, once thought to encompass all, to include all, is now, as he says, sneered at, assailed, construed, so torn apart till if it's so that its framers could rise from the grave, they'd hardly recognize it at all. And as for the Black man, the heavy iron doors, he says, are being closed on him. So they have him now, as it were, locked in with a bolt of 100 keys, which can never be unlocked without the concurrence of every key. The keys in the hands of 100 different men, and they scattered to 100 different and distant places. And they stand musing now, wondering just what contrivance and all the dominions of mind and matter they can produce to make the inevitable, make his escape, the closing of his escape, more complete than it is. So Lincoln said it would be a grave error to say or assume that the public estimate of the Negro is better today than it was at the origin of the government. So what you had here is not a Marxist view of laws of history unfolding, but a kind of classic view that things can go backwards as well as forwards, that even polities founded on the right principles can find themselves decaying, eroding, as if falling away from those principles. They can become corrupt because the individuals who form them become corrupt. Okay, with that. My friend Russ Hittinger pointed out that Lincoln could not have raised his arm and taken the oath on March 4th, 1861 to defend the Constitution if it were thought that that constitutional right articulated Dred Scott was now part of the Constitution as though it had been woven into the text itself. It was a constitutional right not to be dispossessed of one's property and slaves when one entered into a territory of the United States. Now, what the court did was strike down the act of Congress barring slavery from the territories. And so what it had to use was, of course, the Fifth Amendment, the due process clause of the Fifth Amendment, depriving a citizen of, depriving a person of his property without due process. Lincoln said, we're going to sleep in Illinois as a free state. We're going to awaken Illinois as a slave state, because that decision would be extended. And people say, well, nobody sees that, because after all, that decision rested on the Fifth Amendment. And everyone knows that those First Amendment and First 8 Amendments bear solely on the federal government, not the states. And Lincoln suggested they might consider that there are other vehicles of rights apart from the Fifth Amendment. There's a privilege of immunities clause. You could just as plausibly say that it's a violation of the rights of a citizen traveling from one state to another to be deprived of his property in a slave. So Lincoln says, you profess not to see this now. If we let you take the first step, you will see this when it suits your convenience to see it. Lincoln couldn't take that oath because to defend the Constitution containing the Dred Scott decision, because as you know, he led a national movement to counter and override the decision. And that key moment reminds us that the decisions of the Supreme Court commanding high respect, still just can't claim the same standing as provisions in the text of the Constitution. But that response of Lincoln and his administration reminds us of a lesson, I think, quite forgotten in our time, that under the constitutional scheme, the political branches, the executive and legislature, do have some role to play, possible role to play in countering, narrowing, in some cases overturning judgments of the Supreme Court. But the response here of the Lincoln administration was, I think, was quite telling. Lincoln, of course, understood that the Dred Scott decision ran against the deepest premises of the American regime. The only rightful governance over human beings, Jews trust powers for the consent of the governed. And of course, the governing a human being as a slave was to govern him without his consent. He clearly understood the depth of the wrong here. But at the same time, he recognized that, yes, a decision of the Supreme Court still must claim our respect. So he put, as he put it, if the court decides that Dred Scott or anyone else remains a slave, the rest of us will not form a mob to overturn the verdict. But it's another matter if we are not persuaded of the deep principle articulated in the case. That is, we can respect the outcome of the holding as it bears on these two litigants in the distinct circumstance of this case without signing out to the broad principles. So he said, we oppose that decision as a political rule, which will be binding on the voter to vote for nobody who thinks it wrong, and binding on members of Congress to take no measure in which they have to concur with the principle articulated in the Dred Scott decision. But that argument by Lincoln was given the clearest, most dramatic test in the early days of the administration. We have two cases of a black student in Boston denied a passport to study abroad in France on the ground that blacks could not be citizens under Dred Scott, therefore they could not carry passports under the laws of the United States. And a black inventor in Boston denied a patent for the same reasons, that patents should, under the laws, should flow only to citizens. Now, what I point out, these are circumstances quite remote from anything involved in Dred Scott. We didn't have here slaves litigating over their freedom. We had two agencies of the national government, State Department, Patent Office, applying what they took to be the deeper principle of the Dred Scott case to circumstances quite remote from the case. And the response of the Lincoln administration was to quash both decisions, to grant the passport, grant the patent. And a marvelous statement from the Attorney General, Edward Bates, the point was made that any black person born free in the United States is, in the judgment of this administration, yes, a citizen of the United States. Anything in Dred Scott notwithstanding. And of course, that same line, about a year later, in June 1862, Lincoln's Congress passed, Lincoln signed a bill that barred slavery from the Western territories of the United States, any then existing, any that may yet be created. It was a decision it was an act that countered the decision in Dred Scott through an act of ordinary legislation, not a Supreme Court amendment, not an amendment to the Constitution. And the implication was, well, you could have made a mistake as well as any other branch of the government could make a mistake. We'd encourage you to take a sober second look at what you've done. And if this doesn't work, we always could move to the level of a constitutional amendment. Now, as we say these days, I would fast forward to the National Institute of Health in a meeting in the mid-1980s in a panel on fetal research using fetal tissues. And the question was whether the agency, or the Institute, could refuse to use those tissues drawn from elective abortions, deliberate judgments, choices to destroy the child, and whether it could simply confine itself to the tissues drawn from spontaneous abortions. Well, the argument was made, of course, well, Roe versus Wade is the law of the land. It confirmed the legitimacy of abortion, the rightness of abortion. If that's the case, the NIH would be obliged to respect that judgment of the Supreme Court. The alternative argument was made that no, Lincoln's argument is still in play. We can confine Roe versus Wade to the litigants and the circumstance of that case, while still holding back from accepting that the principle involved in that case about the right to destroy the child in the womb virtue through the entire end of the pregnancy. Now, that argument was not adopted by the advisory board, but as I pointed out at the time, that this judgment on Roe and fetal tissues could be wrong only if Lincoln was wrong. And I argued that there is no way in Lincoln's argument could be wrong under the logic of this Constitution. Lincoln's argument, of course, is resisted by liberals in our own time, especially on the matter of abortion. But in a curious way, even the liberals can be backing into the kind of argument Lincoln made. For example, a notable case. In the early 80s, as Mark will recall, the court that did the Chada case, CHADA, on immigration and the legislative veto. The court struck down the legislative veto, the arrangement allowing the executive to take the initiative in putting rules into place and giving Congress 90 days to rescind or veto those acts. It declared unconstitutional. But of course, the legislative veto stood at the heart of an act that was so important to Democrats since the war in Vietnam, and that is the War Powers Act, acknowledging the power of the president to deploy military troops abroad, but now adding to it insistence that we use the legislative veto and give Congress 90 days in which to override it. And yet, since this time, since that Chada case and legislative veto was struck down, Democratic Congresses kept passing legislative vetoes, willing to install them under one arrangement to another. And you go, well, how's that plausible? And the answer is that what the liberals insisted was that the Chada case could simply be narrowed to an understanding of the aptness of that judgment in regard to those two litigants involved in the case, and the understanding of that decision simply narrowed to the matter of immigration. And that leaves us free, of course, to still respect the principle behind the legislative veto as it bears in other kinds of cases, which is to say, they're essentially backing into Lincoln's argument, which confirms, I think, the main point I'd make here. The Dred Scott decision compelled people in high office to think again about the question about the grounds in which a majority of 9 judges, a panel of 9, can impose a policy on the whole country, a policy that can be countered only by rising to the level of a constitutional amendment. And I think the explanation, set down by Lincoln really gave us the clearest expression, clearest exposition of the logic that must be contained in the cast of our separation of powers. I think it's telling that even liberals in our own day find the need to keep working their way back into Lincoln's argument when they encounter judgments of the court that they find morally objectionable. So we discover, as I say, that there's a deep logic to the Constitution that will always be there to be discovered anew. And when it is, we encounter the surprise of realizing it's been there all the time. Okay. I yield.
Professor Graber?
The most common phrase now in Zoom conferences, please remember to unmute and mute. It's a great honor to be here with a number of scholars who I've respected and learned from throughout my academic career. And given how long my academic career is, that Professor Arquez I've learned from the very beginning. He has been just a place, in some ways, a dueling foil, but an important, articulate foil. If he did not exist, I would have to invent him. And we have a number of disagreements about Dred Scott, though I probably phrase our disagreements differently than he might, which may be another disagreement. One version is sort of a liberal, and now you're going to learn why Dred Scott really supports abortion rights and why Dred Scott really supports everything I think is right in the world. But actually, what I teach my law students, when I teach Dred Scott, and I teach Dred Scott early, is Dred Scott is the central case in the American anti-canon. It is, as I sometimes say, the old maid of American constitutional law. For those of you who remember the card game Old Maid, if you get stuck with the old maid, you lose. And if you get stuck with Dred Scott, you lose. We see in litigation, each side trying to say what they're really doing is Dred Scott. So in fact, Tawney claims to be basing his opinion on the original understanding of the Constitution. Well, if Dred Scott is an originalist decision, then originalism just has to be wrong. And Curtis says, no, I'm the true originalist. So if the dissents to Dred Scott are based on originalism, then maybe originalism is okay. The most infamous line in Dred Scott is probably Black people have no rights that whites are bound to respect. And what I go through is substitute your favorite group that you want to protect. Fetuses have no rights the majority is bound to protect. Women have no rights the fetuses are bound to protect. And as Professor Arkes correctly points out, when people are systemically frustrated by the Supreme Court, suddenly they discover Abraham Lincoln's departmentalism, or I would call it partisan supremacy. When they like the Supreme Court, suddenly they're much more judicial supremacists. So there is no greater judicial supremacist on the court than Chief Justice Roberts and Neil Gorsuch, who have basically said the Republican effort to curb the Supreme Court in the wake of the Civil War, so in fact, we could actually free African Americans. In practice, that was a terrible thing. And one notion is, oh, good, they haven't learned the lesson of Dred Scott, because frankly, they're on the other side of the fence. But I assure you, when my side wins, we're going to start becoming judicial supremacists. That's the way the world works. What I want to do today is take two features of Dred Scott that cross our ideological lines, that make the decision puzzling, interesting, that say some things about 1850 that don't have good analogs in 2021, but help us to understand our polity and some of its issues. The first is an interesting feature of Dred Scott. It is a feature that helps all casebook editors because it is 20 pages that we all cut. It is what Tawney thought he had to spend most of his effort on. And that was getting the Bill of Rights in the territories. So Professor Arkes correctly points out, I think here there's a scholarly debate, but I'm on his side on this one, that Tawney did think it was a Fifth Amendment case. But for the Fifth Amendment to work, Congress has to be bound by the Fifth Amendment when Congress is not simply governing states, but territories. And no less an authority than Daniel Webster rejected this position, that for a great many Whigs, the Bill of Rights was off when Congress was governing the territories. And so Tawney spends 20 pages, and the dominant argument is one I suspect most of us might agree with, liberal, conservative, anarchist, whatever, namely, the United States ought not to be an empire. The limitations of Congress go with Congress wherever Congress governs. If Congress is governing they can't create titles of nobility. If Congress is governing, they can't violate the freedom of speech. If Congress is governing, they can't violate the Fifth Amendment. And it's important to understand that was the fight Tawney thought he had to make, not on the meaning of the Fifth Amendment. Thought if he got the Fifth Amendment into the territories, he was 3/4 of the way there. And then he offered an interpretation of the Fifth Amendment we can talk about later. Now, here's what's interesting. We fast forward to the 1890s, and now the United States has a new set of territories. And what did most liberal thinkers, and liberal is the wrong word, say? We actually have a very good precedent. Congress cannot violate fundamental rights in the Philippines, in Cuba, in Puerto Rico. Why? Dred Scott. Dred Scott says if Congress is governing, we cannot govern as an empire. We only can govern by the Bill of Rights, and it's rather interesting. This loses. And most liberals today think that's a disaster. And by the way, most conservatives today are inclined to think the Insular cases were wrongly decided, that there was a liberal strand in Dred Scott about the limitations of Congress' power, about fundamental rights. And that's sort of been lost to history because, of course, you cannot cite Dred Scott. Even when Dred Scott is on your side and in fact stands for a principle some people might say is liberal, I don't really care. I think it's a good, decent principle. When Congress governs, people ought to have freedom of religion. When Congress governs, there ought not to be cruel and unusual punishments. A second feature deals with one of the reasons why Tawney denied African Americans could be citizens. He says citizenship comes with rights. And when we look at African Americans, even in states where they're allowed to vote, and by the way, a small aside on that, there's a debate between Democrats and Whigs. Democrats think non-citizens should be allowed to vote. Whigs reject this. Lincoln and Douglas had this debate in 1843 in the Illinois Constitution. So in some sense, this debate between Lincoln and Tawney is an earlier debate that first had nothing to do with persons of color. But we can give non-citizens rights, but citizens have rights, a robust set of rights. Curtis said no. The mere fact that African Americans are routinely denied rights throughout the country isn't relevant. Citizenship has nothing to do with rights. Well, now again, we fast forward. But now we only have to fast forward 8 years to 1865 and 1866. In 1865, the 13th Amendment is ratified. Most Republicans think through the ratification of the 13th Amendment, African Americans become citizens. Does any question? First, the Civil Rights Act of 1866 declares African Americans citizens. The 14th Amendment passed in 1868, ratified in 1868, declares persons born in the United States citizens. And what do Republicans now argue? In enforcing these things, citizenship has a robust set of rights. If you are an American citizen, that's not like having a chair. They announced we had chairs in different places. I don't know about Hadley. Most of our chairs come with nothing. It's a great honor, so to speak, but there's no money, there's no rights, there's no privileges. Philip is smiling. He may have one of those chairs like I have. And Curtis's citizenship is like that. It's a great honor to be an American citizen, but it comes with nothing much. For Tawney, citizenship comes with a robust set of rights. And so the minute African Americans become citizens, we see a flip. Republicans are now saying that Dred Scott opinion, lousy on a lot of things, but got citizenship right. African Americans are citizens. They deserve a robust set of rights. And Democrats say, no, we've reread Curtis. You know what? He was better than we thought. Notice the same flip that takes place on judicial review. Turns out the mere fact that African Americans are citizens, it's still a white person's government. I'll leave with one last thought about Dred Scott and its influence then on a debate that no one associates with Dred Scott. It's the debate, why is there no socialism in the United States? One idea, people on the left say the lower classes need to combine to overthrow the more elite, or at least to get their way. But notice in Dred Scott, Tawney in many ways is the defender of poor white rights. Poor whites have citizenship. It's robust. African Americans don't. Poor whites are being pitted against African Americans. Different citizens in the territories are being pitted against each other. In these different ways in which American constitutionalism consistently pits the lower classes against each other, we may see why the American regime goes in different paths in the 20th century than some European regimes. Thank you very much.
Thank you, Professor Graber. Professor Tubbs.
Thank you. A 19th century St. Louis newspaper once referred to Dred Scott as illiterate but not ignorant, and described him as having strong common sense. But in the suit to end his bondage, Dred Scott needed something more than common sense. In the words of historian Don Fehrenbacher, Scott was required to be enough of a citizen to use the federal court system. This requirement was somewhat paradoxical because Scott was seeking his freedom in the most basic sense and not a broad array of civic rights and privileges. In the United States, we sometimes forget that having the status of a free person does not necessarily entail certain civic rights and privileges. This disjunction, in fact, is the historical norm rather than the historical exception. Even today, we regard some civic rights as alienable, such as the right to vote, which can be irrevocably lost in some states if one is convicted of a felony. In my presentation this afternoon, I would like to comment on Dred Scott's quest for freedom. As a subject of theoretical or philosophic reflection, freedom is inexhaustible. And for similar reasons, I cannot imagine our nation's engagement with Dred Scott's unsuccessful quest for freedom ever coming to an end. In what follows, I aim to summarize two recent interpretations of Dred's fate, followed by a few of my own musings on the topic. I shall conclude by advancing one admittedly tentative argument about Dred's unhappy fate. In rejecting Dred Scott's suit, the Supreme Court issued an egregious ruling, perhaps the most egregious ruling in its history. In time, the ruling became infamous, and much of the infamy resides in its sweeping assertions about Black Americans, especially in relation to white Americans. Because some of the assertions in the majority opinion by Chief Justice Tawney were demonstrably false, the court's ruling could also be described as mysterious, generating much perplexity over the last century and a half. During this time, scholars and jurists have sought to dispel some of the mysteries of Dred Scott versus Sandford by investigating the sources of the ruling and probing its deeper meanings. These efforts have enlarged our understanding of the case and led to some notable interpretations of it in the context of US history. Consider two such interpretations. The first interpretation, the more widely held view, holds that the Supreme Court's ruling in the case should be seen as a predictable development in a political community that adopted a pro-slavery constitution. The second interpretation, put forward by the late Don Fehrenbacher, asks us to see the ruling as the culmination of what Fehrenbacher called a pro-slavery gloss the Constitution acquired in the 19th century. By pro-slavery gloss, Fehrenbacher meant a way of reading the Constitution that favored the interests of slaveholders in slave states over those persons in states opposed to slavery. Fehrenbacher argued that the original Constitution was largely neutral on the matter of slavery because it was essentially, not wholly, but essentially a state institution. But because the Constitutional Convention in 1787 sought to increase the powers of the national government, it had greater pro-slavery potential and greater anti-slavery potential than did the Articles of Confederation. Thus, the meaning of the Constitution with respect to slavery would greatly depend on the specific provisions on that subject that ultimately found their way into the document. The difference between Fehrenbacher and those who today see the Constitution as a pro-slavery document could be summarized in this way. In his interpretation of various constitutional clauses pertaining to slavery, Fehrenbacher emphasized certain contextual facts, which sometimes revealed that the pro-slavery cause at the Constitutional Convention was frustrated in significant ways. By contrast, those viewing the Constitution as a pro-slavery document have believed that those contextual facts were not as consequential as persons such as Fehrenbacher have thought. The debate about the 3/5 clause of Article 1, Section 2 seems to illustrate this. The section provided that representatives and direct taxes should be apportioned among the states according to their respective numbers determined by, quote, adding the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed 3/5 of all other persons, end quote. Citing Frederick Douglass, Fehrenbacher argued that that counting slaves as 5/5 of a person would have meant an even greater political bonus for the slaveholding states. But perhaps the bonus that accrued to the states by counting slaves as 3/5 of a person was consequential enough. As Michael Stokes Paulson has recently argued, the slave states in the South consistently had 1/3 more seats in the House of Representatives than they deserved based on their free population. In addition, the 3/5 bonus influenced presidential elections, since the number of electors in the state is based on the total number of its senators and representatives. The pro-slavery bonus, according to Paulson, thus tilted presidential elections in favor of Southern pro-slavery presidents. As Paulson points out, Southern slaveholders served as president for 32 out of our nation's first 36 years under the Constitution, and for 50 of the first 72 years. The curious thing about Fehrenbacher's argument about the pro-slavery gloss in the 19th century was the source of that gloss. He believed that the gloss was mainly attributable to Southern control of the federal government, meaning not only the Congress and the presidency, but the State Department and the Supreme Court. Such control created a false national narrative about the Constitution as a pro-slavery charter. And Fehrenbacher described the majority opinion in Dred Scott as a pro-slavery document from beginning to end, especially the assertion that Black Americans had no rights that whites were bound to respect. In sum, Fehrenbacher argued that Dred Scott versus Sandford was the culmination of that pernicious gloss that the Constitution acquired in the 19th century. But those who believed that the Constitution was essentially a pro-slavery document could easily argue that the pro-slavery gloss should have been expected, given the political bonus that accrued to the Southern states in the original Constitution. Whatever the resolution or non-resolution of the scholarly debate, I believe that it illuminates much of Dred Scott's travails. But for my part, the debate seems to assume that Dred Scott's fate was ultimately determined by the actions of a relatively small number of men in 19th century America. That is, the debate seems to have very little to say about the ways in which ordinary people in our republic helped to sustain slavery. This, I believe, is a point that Professor Graeber was getting at in his concluding remarks. The idea that the actions of some persons are more influential than the actions of others is easy to accept. But even in the late 18th and early 19th centuries, the United States was by historical standards a large republic and not as dependent on the words and deeds of a small elite in the way that, for instance, the early Roman Republic was. If slavery was an evil, some persons must be deemed responsible for its persistence in the United States after the convention in Philadelphia and after the votes were counted in the state ratifying conventions. Given the magnitude of this wrong, there are surely degrees or gradations of responsibility and culpability for chattel slavery. How might this be captured? The approach that I favor, which I wish to summarize here in my conclusion, comes from just war theory. In his famous restatement of just war principles, Michael Walzer discusses the matter of assigning responsibility for violating certain strictures relating to the initiation of war. In just war theory, aggression refers to one sovereign state launching an unprovoked attack against another. In exploring this problem, Walzer put forward several principles about individual and collective responsibility for the crime of aggression. Those principles are relevant here. Walzer refers to modern democracy, representative democracy, as a way of distributing responsibility. But this does not mean that all adults in a democracy share equally in the blame to be assigned for an aggressive war. With respect to ordinary citizens, the amount of blame is a function of the social position of the individual, how much influence he or she might have over policy, and the person's conduct with respect to the war of aggression. Applying these notions to our republic before the Civil War, we should be able to see gradations of responsibility and culpability for the institution of chattel slavery. We could distinguish public officials from lay persons while recalling that women were then denied the right to vote. And then until the Jacksonian era, most states required white men to own property as a condition of voting. In this reckoning, the most culpable persons would be those public officials who sought to preserve and extend the rights of slaveholders, including, I dare say, the majority in Dred Scott versus Sanford. The least culpable public officials would be those federal officials who developed strategies to end slavery in the country through legislation for the federal territories and the high seas, as recently summarized by James Oake in his book, The Scorpion Sting. Among lay persons, the most culpable would be those who owned slaves, regardless of how well the slaves may have been treated, because nothing forbade the owners from freeing them. The least culpable would be those we now call abolitionists, though some of their methods raise difficult moral questions. As these remarks suggest, I am deeply interested in those laypersons who always seem apolitical or at least undecided about the great questions being discussed and debated in the antebellum era. This group would seem to be most of the American people, but in the absence of certain facts about them, that might come from their correspondence or diaries or local newspapers, it is hard to establish their degree of responsibility and culpability. But this fact does not mean that these persons are unimportant. From the standpoint of the growth of chattel slavery in the 19th century, they are extremely important, and even more so if we seek to understand the life and unhappy fate of Dred Scott. Thank you.
Thank you, gentlemen. We have a few questions already from the audience, but I wonder if I might open it up to the panelists themselves, if anyone wanted to comment on. Go ahead, Hadley.
No, I just want to see what's at issue with Mark, because to use a phrase of a colleague of mine, Mark and I could be in heated agreement. We're not, I don't think we're arguing about the Bill of Rights applying to the territories. That can't be the issue. And of course, Bill of Rights does not protect solely citizens. The protections cast in the Bill of Rights apply to persons, not really to citizens. But the argument would seem to be as to whether they were justified in invoking the Fifth Amendment to defend the right to hold somebody in slavery. Now, it seems to me at that point you could even take one of two paths. I don't attach myself to the argument made by conservatives today, vying against Dred Scott as substantive due process, that you went beyond the due process clause to fill the substance by reaching a judgment as to whether slavery was justified or unjust. No. As Mike knows, substantive due process are us. That's what we do. But if it's there are two paths. One is the substantive judgment. When we'd argue about abortion, I wouldn't say, well, it depends on what is in the text. Persons are only fleeing extradition. They must be postnatal. No. The question is, what is it? What do we have before us? Do we have a human entity? And if we do have a human entity, there's no principal ground to which we deny it. Well, the laws on homicide are utterly different to the age and the size of the victim. And so the taking of that life, that small person has to be justified. If I use this in relation to Dred Scott, Lincoln said, the question is whether the black man is not or is a human being. And Henry Jaffa said, that can't be a value judgment. We just far out to see what people think about that or whether they value protecting black people as real persons. Well, at that point, we would say, no, if you can't deny the personhood, the human standing of the black man, that's not a matter of value judgment to cast out. There's an objective truth there. If that's the case, yes, it does cast a serious pall over this matter of slavery. And it gives the court sufficient justification for saying, no, we can't sustain this kind of assertion of property. And Daniel Webster said, what do you mean property? Property is defined by the local law. And we never took the notion of slave property as something to be carried into the national sphere. Now, if it's a matter of originalism now, due to originalism, what's in the text about fetus? What's in the text about? Well, you have Justice Curtis's point that the fugitive slave clause was cast in terms of people held to service under the laws of either state. That is, it was so widely understood that slavery was so incompatible with natural law that it was understood that it could be sustained only by positive law. And that sense was held in the border states of the South as well as the North. Then as Lincoln says, look at the whole scheme. There's no endorsement of slavery in the text of the Constitution. We know why. Alvar Ellsworth says we should have no trace of that institution when, as we hope, it will pass away. You've got a policy to block the extension of slavery to the West, a policy to block the import of new slaves. So as Lincoln says, we don't endorse slavery, only covert language is used, and all of the scheme here, as we see it, is not a scheme of promoting, endorsing, and encouraging, but denying and discouraging, right? So it seems to me from either angle, I mean, we can make the case substantively against the reasoning of Dred, quite apart from whether you think the First Amendment's applied to the various as I do. So I'm not sure where that leaves me where that leaves Mark and me at odds on anything. I'm curious as to where it would.
Mark, do you want to?
Okay, well, there are points of agreement, points of disagreement, and points of just simply talking past each other, which is what academics do best.
Right.
Points of agreement, if I in any way meant to imply Hadley might disagree with the Bill of Rights in territories, I apologize. I did not intend that. And I fully share the belief. I think part of what I want to suggest is I don't think Dred Scott helps us a lot with modern problems. I don't think the law was as clear. And just to be simple, because I've got a whole book and you can think it's right and you can think it's wrong. Some people think both. But first, as Professor Arkes correctly pointed out, there's a very important decision, Somerset versus Stewart, which says slavery can only exist by positive law. And Curtis seems to think that's the rule in the United States. And some people said so. and some people didn't. Here's one very important fact that cuts against it. In fact, when they organized the Northwest Territories, there is an explicit clause that says no slavery. When they organized the Southwest Territories, there is no clause that says anything about slavery, and slavery was legal. This seemed to imply that, in fact, if anything, if you wanted no slavery, you had to say so by positive law. And my feeling is this is a lawyer's game, that one side can point out the Constitution does not mention slavery. The other side, 20, can quite correctly say, gee, but it gives every euphemism known to mankind, so we know exactly what is going on. We're not talking about horses escaping to other places. We're not deeply worried about apprentices. And it's simply what's wrong with Dred Scott, I've always argued, is what's wrong with slavery and racism. And you ought to read the Constitution like that. But if you believed in slavery, if you believed in racism, you could make perfectly plausible arguments. With respect to abortion, we can be here all night. A crucial issue depends on what's a person. And one, as far as I'm concerned, perfectly plausible view is a person is a genetic human.
What?
A person is a genetic human being. All you need is the gen. On another view, you need more. That is also held by decent people. And my own view is Abraham Lincoln says nothing relevant about which definition of person is right, since Dred Scott satisfied everybody's definition of person today.
Mark, can I follow up with you? Your point about the Southwest Territory is interesting, and that slavery, you say, was legal there. How do we know it was legal there if there was no positive law?
Well, one way we know is good law and society scholars. Lots of people had slaves. Nobody challenged the legality of slavery there. It's the same way we know that having ice cream was legal in the Southwest Territories. Lots of people had it. Nobody challenged it. Remember,
I'm not sure. I'm not sure that. I mean, I have to think about that. I don't think that's sufficient to establish its legality, actually.
I think, well, once, we can play lawyers' games, but we have court decisions that assume slavery is legal in the Southwest Territories. We have everybody operates on that assumption. Abraham Lincoln never says slavery was banned in the Southwest Territories. He does talk about the West, but interestingly, he never makes the claim that slavery was illegal in American territories east of the Mississippi.
And I should make clear, I speak from ignorance. I just don't know.
Yeah.
I don't know the matter. So these are just factual questions. There's no federal congressional legislation explicitly saying one way or the other in the Southwest Territories. And you're saying there's lots of are all the court decisions the same way, that slavery is protected insofar as the
not that it's the court doesn't say slavery is legal. The court operates on the assumption that this isn't something any litigant even bothers to challenge. And notice there's Somerset out there. So in some ways, there's a basis of a challenge, and Southern jurists can say, once again, with some justification, gee, we're seeing Somerset challenges in the North. Nobody is making Somerset challenges in the South.
Very interesting. David or Hadley, do you want to comment on this?
Well, Lincoln pointed out that people were holding slaves in the Southern Illinois. getting away with it. There's a little play in the system. They couldn't play in the system in the South. What they've been doing was saying, all right, we'll look the other way, but don't ask us to endorse it. And there's no question about Lincoln's holding that it is wrong. Where is it wrong to rule a human being as we rule dogs and horses anywhere in the world where that difference in nature remains? There's no question about his judgment about the wrongness of slavery wherever it existed. His position as Marxist is one of prudence, that for the sake of avoiding a war, I'm willing to say, no, we have no authority to reach it in the separate states. And yes, I've been willing to even accept extension of slavery in the West, as long as there's some addition to the domain of freedom as well. We can do something to negotiate this thing on a prudential way. But none of that dislodges his conviction about the deep wrongness of principle everywhere. And after all, look, remember Alexander Stevenson's Cornerstone speech, 1859. The problem was those founders from the South were just as bad as those founders from the North. They too were under the superstition, all men are created equal, and they're just too timorous to defend their position forcefully.
The argument has been changed subtly, and it's important to understand. I'm not disputing that Abraham Lincoln thought slavery was wrong everywhere.
Oh, I thought you were. Okay.
Yeah, I'm disputing simply a point about Somerset, which is, why is it that Lincoln says, you see, they banned slavery in the Northwest Territories. But if Somerset is the law of the United States, slavery was also banned in the Southwest Territories because it did not exist by positive law. Lincoln never says that. Nobody says that. This is once again a point I want to make. It's not all one way. I can show you places in American law where people make Somerset claims. But we need to understand that Tawney could equally point out other places where if Somerset was universally accepted, people would have made Somerset claims, and they didn't.
Is there any disagreement, Professor Graber and Professor Arcus, between you on what Tawney says about Congress's power to regulate slavery in the territory? If memory, I haven't gone back and read the case, but if my memory is right, he says, well, that power to Congress's plenary power in the territories only applied to those territories existing in 1787.
That was also Monroe's view. So it's important to understand that this view, the Tawney opinion, was first written in 1820 in the Missouri Compromise. So at least Fehrenbacher may be right that it's a gloss on the Constitution, but it's important. It's not a gloss that developed with John C. Calhoun in 1830 or what's his name, Tawney, in 1856. But shortly after the Louisiana Purchase, you get a raft of arguments, by the way, some of them coming from the North on different grounds, that the Louisiana territories are constitutionally different than the other territories. What we don't have are any arguments from the framers as to whether territories meant simply the existing territories now. So all we can say is when the issue first came up, Americans divided, and it wasn't simply pro-slavery people saying one thing and anti-slavery people saying another, that in fact, our natural readings of the Constitution on so many things just weren't theirs. And this is an historian's point, it's not a lawyer's point. The past is a different country.
Let me get to some of the questions that have been posed by folks writing in. James Mueller, Jim, thanks for watching, asks, why did Tawney, who defended rights of Black Americans early in his career, later decide to deny them? So a question on Tawney himself and his, I guess, his own personal or political thinking, legal thinking. I don't know Tawney's early work early thoughts on this. So
He did a defense of a slave in a notable case in Maryland. But I don't know, maybe Mark knows more, but I assume that the Southerners would say, well, he's grown in office. I understood the
Here,
great nature of things now.
one way of understanding slavery, and by the way, it's a way of understanding gender or any other status hierarchy, is that people who play their role in a status hierarchy often get benefits. So it's not simply Tawney defending slavery. If we look at probate cases in the South, if owner manumits faithful slave and dissolute heir tries to challenge, faithful slave often wins. That people who beat another person's slave got punished. So there were numerous ways that if a slave was not challenging the fundamental rules of slavery, as in the people Tawney was defending, many Southern slave owners would protect their rights, or rather the rights of the white owner. But if the white owner said, I free the slave, well, the system of slavery said the slave wins the freedom lawsuit. So we shouldn't be surprised. Once again, there are a whole bunch of suits, and I suspect David knows them better than anyone given his research, where women in the 19th century beat men because those women were acting in the way the status hierarchy said women should act, and the men were not acting the way the status hierarchy said men should act.
David, do you want to get in on this?
I have to get David into this.
I would say that based on my knowledge of Tawney, he did, according to different sources, believe that something like a comprehensive solution to the sectional crisis could be presented in the Dred Scott litigation. And of course, the decision was greeted with much euphoria in slaveholding states and denounced throughout the North, even by persons who did not consider themselves abolitionists. And I've often wondered whether Tawney's reputation in the South was solid long after the Civil War. If you recall, in Cooper versus Aaron, the court actually cites an opinion by Tawney on the doctrine of judicial supremacy, a remarkable citation in view of what Cooper versus Aaron was saying. But I've thought about this a lot, and that is, I'm actually surprised we have this new magnificent biography of Justice John Marshall Harlan. I think the last time a biography of Tawney was published was 50, 60 years ago. And I'm just expecting fairly soon somebody's gonna take on that project, and we all stand to benefit from it if it's done by the right person, so.
Interesting.
Actually, may I draw David on a little bit more on his point he was making about the complicity of people in the North with slavery? David, I mean, Lincoln would say, look, let's not be clear on these moral gradations. There are many people in the North who benefited from slavery, and there are many slaveholders who free their slaves at the North. Okay, what was the further line you were making on this one, David?
My point is that I'm very interested in what we might call the historical duty, the historical task of assigning responsibility for great political crimes. Your former colleague at Amherst, George Kateb, Mark, in his book on Dred Scott, refers to constitutional evil. George's essay on political evil investigates this from the standpoint of political theory. I'm very interested in it because I believe, to borrow the typology of a historian of the Second World War and The Destruction of European Jewry, Raul Hilberg. One of the last books that Raul Hilberg wrote was called Perpetrators, Victims, and Bystanders. I'm very interested in part because of Fehrenbacher's argument about the spread of the pro-slavery gloss. Very interested in how slavery spread in the 19th century and the role of ordinary people in both the North and the South in contributing or to the spread of it or contributing to the efforts to bring it to an end. So a very recent book by this historian at Northwestern University, I believe her name is Nancy Mazur.
Kate Mazur?
Yeah, Kate Mazur, yes, okay. I think I have it with me. So this is the kind of research that I find inspiring. The book is called Until Justice Be Done, and it's looking at efforts in many free states to turn back laws that discouraged settlement by free African Americans and restricting their rights to testify in court, move from place to place, work, vote, and attend public schools. She describes it in the subtitle as America's first civil rights movement from revolution to reconstruction. So I'm aware of this part of the story, and I'm also interested in the different kinds of complicity that existed elsewhere. And I think Mark was getting at something very important in his the conclusion of his presentation when he talks about a certain kinds of politics being prefigured by the Dred Scott majority opinion. The sense of all Southern whites had one thing in common, which was their superiority vis-a-vis all blacks, regardless of how accomplished a black person might be. A mentality that seems to persist after the Civil War, during segregation. And it, to me, is an element of Fehrenbacher's account of the pro-slavery gloss. And it's deeply distressing from the standpoint of all of Lincoln's arguments about what the framers envisioned and the prospect of slavery being put on the road to ultimate extinction. Fehrenbacher, I think, is very receptive to that. I think Fehrenbacher believes that if certain things had gone differently in the 19th century, that might have happened. So he begins the investigation of the pro-slavery gloss. And as I said, the curious thing about it is that he attributes the gloss primarily to Southern dominance of the federal government. And what he doesn't seem to acknowledge is perhaps that Southern dominance came from the political bonus in the original Constitution, the political bonus accruing to Southern states.
Okay, but then, are you moving toward a notion of collective responsibility, David? Are you going that?
Not universal collective responsibility, because I believe some people admirably resisted slavery, opposed it in principled ways. I don't accept the idea that the nation was founded on slavery. I don't accept the idea that the Constitution was a pro-slavery charter. I believe, if you press me on this, that the Constitution countenanced slavery in those states where it existed. But I believe, having been influenced by many of your arguments, Hadley, I believe that the natural rights philosophy of the Declaration and the preamble to the Constitution set the political agenda for the nation. And the ideals were betrayed in the 19th century with the expansion of slavery. But the ideals are extremely important. I tell my students, the ideals are always there, and the ideals must be acknowledged as a fundamental part of our history. And the fact that we have statesmen such as Lincoln reflecting on the ideals and aspiring to bring us closer to those ideals, that's the legacy of not only Lincoln himself, but the founders and the Declaration of Independence.
Can I introduce a few questions, slightly modifying them, that our audience has asked? Bill Dawson asks about what position did Lincoln take with regard to the Dred Scott decision? Hadley, you talked about that in your comments already, but maybe I can modify the question just a little bit and ask what was the political effect of the Dred Scott decision, do you think, on the the Lincoln-Douglas debates in 1858 and then the presidential election of 1860? Does the Dred Scott decision doom Stephen Douglas's candidacy ultimately and lead indirectly to Lincoln's election? Is that?
Oh, absolutely, absolutely. It was look at the last debate in Alton, and Lincoln says, "I have 10 minutes left." So Douglas had to straddle two positions. He wanted to take the position of popular sovereignty. I don't care whether slavery is voted up or down in the separate territories, as long as it's done democratic way with a voting majority. On the other hand, he was obliged now to defend the decision in Dred Scott. And if that's true, then I have a constitutional right not to be dispossessing slaves when I go into territory, whether the majority in the territories are no longer free to vote to keep slavery out. And Douglas tried to get out of it with the Freeport Act and say, oh, yes, you may have, there's this abstract right, but that right will depend on many municipal regulations to enforce it. And if you're really opposed to slavery, you could simply withhold your support from these rules. Well, there Lincoln jumped. He said, we have the Fugitive Slave Clause. That is part of the Constitution, and that is in the text. And if you're telling me that local authorities are free simply to withhold the support of that text, they're free to obstruct it. I have a right, but you're free to obstruct. Or as Lincoln put it later, what Douglas is telling you is that a person may bring his property into a place where he has no right to be. If what you're telling me is that the constitutional provision may be obstructed by simply withholding your respect for the constitutional provision, well, what you say here extends to the Fugitive Slave Clause, and which means, as Lincoln said, there is no greater abolitionist in the country by Douglas after all. It is right. When have you seen a political debate have this kind of substantive effect? Douglas talked himself out onto a limb. He couldn't defend both. What the South wanted was a slave code for the territories, and Douglas could not give him that. And as soon as Lincoln drew him out on those things, Douglas could no longer get the nomination of a united Democratic Party for his campaign, his candidacy. Well, the result was it split the Democratic Party and facilitated Lincoln's election.
Do you think, let me ask an impossible counterfactual, but if Dred Scott comes out differently, does Douglas win in 1860?
May I?
Please, yeah.
Just if I could tell a slightly different story. First, we need to understand in 1854, Kansas-Nebraska Act, Congress repeals crucial parts of the Missouri Compromise. So to some extent, as a number of people said, Dred Scott, the territorial issue, was largely a hypothetical. Wow. And in 1854, the Democrats take a bath in the North. And Douglas develops a strategy. What he says is, here's the story. Yeah, Kansas is nominally a slave territory, but not enough slaveholders are moving there to make Kansas a slave state. And what we really care about is a free state, slave state. Is that argument working? The only evidence we have are elections. What we know first is in 1856, Democrats gain half the seats they lost to Republicans. Then Dred Scott comes down. And if the theory Dred Scott was a disaster for Democrats, we'd expect the bottom to fall out. Unfortunately, the 19th century does something wonderful. There's not an election day. Every state holds elections at different times. So Dred Scott comes down. Some states have an election in April, in late May, in early July. And for the next 8 months, Democrats beat the tar out of Republicans, with Republicans screaming Dred Scott and Democrats saying, Who cares? Kansas is going to be a free state. In November 1857, Buchanan accepts the fraudulent Lecompton Slave State Kansas Constitution, and that's when the bottom falls out of the Democratic vote in the North. That is what forces Douglas to adopt the Freeport Doctrine, which he had not adopted before the Lecompton Constitution. So it suggests, at the very least, Dred Scott is at most a minor player, because there's no evidence anybody switched to being a Republican as a result of Dred Scott, where there's tremendous evidence about the Kansas-Nebraska Act and Lecompton Constitution. Now, I'm not simply a quantitative social science, so if someone wants to say, yeah, there are lots of other, effects going on.
But Mark, is it?
But if we were to look at voting, you would simply look at voting data. You would say Kansas, Nebraska, Lecompton, not Dred Scott.
But isn't the real question, did Democrats abandon Douglas because of Dred Scott?
Certainly not. Well, first of all, remember Douglas.
So why does the Democratic Party split though then?
They split over Kansas, Nebraska. Douglas, why does Buchanan say Douglas must be defeated? It's not Dred Scott. It's Lecompton. What Douglas understood was the North could stomach Dred Scott. The North couldn't stomach Lecompton. Douglas breaks with the Democrats. That's in some ways what Lincoln is doing, is less beating up Douglas on Dred Scott. He's beating up Douglas on Lecompton. That is, Douglas is trying to hold together a party, the northern wing of which can't stand Lecompton, the southern wing of which loves it. That's the bigger wedge. And it fits in some sense something we know about politics.
Okay, Mark, for those who don't play inside baseball, could you remind people, say, what was the part of Lecompton that the Democrats couldn't stomach?
Okay, the Northern Democrats, Southern Democrats. There are two elements of Lecompton. First, the proposal was to admit Kansas as a state, even though Kansas had nowhere near the population anyone thought for a state. Second, it was to admit Kansas as a state with a slave constitution. Slavery was clearly mandated in the Kansas Constitution, even though the vote appears to be fraudulent. That is, the general agreement of historians was on any fair vote, a free constitution wins, and it's not close.
David, anything on this point here, this historical point?
I think Hadley did a fine job of summarizing Lincoln's response to the Dred Scott decision. I've often thought that Lincoln maybe is indirectly acknowledging the existence of the pro-slavery gloss when he talks about how the position of Black Americans in the United States is worse in 1857 than it was early in the 19th century. He seems very distressed by the developments that Hadley summarized. And in reading Fehrenbacher, I made that connection between Lincoln's statement as well as the Fehrenbacher historical argument.
I want to go back to this is Lincoln's response to the Dred Scott decision. We had a question about that. Let me see if I can find it here. Let me just throw it out for discussion. When I teach Lincoln's speech on the Dred Scott decision, one of the questions I get from my students is, this seems to be a very comprehensive account on how to think about Supreme Court decisions that are incorrect. And I had a question last semester in class: has anyone developed a better theory than Lincoln? What do you do if you think the Supreme Court is wrong? And I said, not that I know have. But I asked my students' question to you. Is Lincoln's speech on the Dred Scott decision, has anyone surpassed it on what to do if you think the Supreme Court gets it wrong?
as I said, I think it's the most persuasive and within the cast of this Constitution.
The one here points to something rather interesting. You can actually find it in Martin Van Buren's work.
Interesting.
And the speech is misunderstood. It is not a speech, and particularly the first inaugural, about departmentalism.
Mhm.
What Martin Van Buren believed, and I'm actually working on a book on this with Reconstruction because we can only understand the Reconstruction amendments in light of this belief, was the way we protect the Constitution is most people are in fact loyal to the Constitution. It's these elites. Van Buren called it the money power. Lincoln and Salmon Chase called it the slave power. What we need to do is to organize the party of the people to defeat these unrepresentative elites, and the party of the people will return the Constitution to its pristine state. So in the first inaugural, it's important to say Lincoln doesn't say, I'm the president. I get to overturn the Supreme Court. He says, if we take a Supreme Court decision as valid the instant they have made, we have in fact taken the power of the people and put it in that tribunal.
Right.
First inaugural.
Yeah.
At the first inaugural. Yeah, you can have a contrived case, a bare majority can produce this outcome and take it and require a constitutional amendment in order to override it. I was involved in in hearings several years ago on the Born Alive Act, and I was talking about this issue of the political branches offering a counter. And my old nemesis, Jerry Nadler, leaned in and said, well, Professor, if we're trying to deal with cases we can change, how about Bush versus Gore? And I said, that's a good thing, Congressman. You ought to try your hand at it in practice, but just remember, you're still going to have to respect the judgment of the case in regard to those two litigants.
Very good. Very good. Do we know, I want to go to Roger Taney again, a little biographical information about him. Do we know, did he write anything about Dred Scott after Dred Scott? You know, do we have any comments by him in the 1860s? He must have thought, I've always imagined this, I'm not sure if this is actually right, that Roger Taney thought he was helping to avert a civil war. And then the Civil War comes. Does he comment on this? Do we know?
He doesn't comment on that, but he does produce a long memo that's in one of his biographies in response to Curtis about, here are more reasons why I'm right. The memo doesn't, in my judgment, help his case at all. And I'm one of the people who says this case is not as bad as people think, but it is what it is.
But we have no sustained reflections on his.
No, he did. What we do have during the Civil War is he drafted opinions declaring the habeas corpus, which he actually wrote, the draft and legal currency unconstitutional, and kept them in his file. One has been published. I'm actually working on something to publish the other, that he was a consistent effort thorn in the Union side. There's a letter from Samuel Miller saying, I spent my time during the Civil War preventing the court from issuing contrary opinions. That he didn't say who he was targeted against, but it seems fairly clear.
Interesting. There's a question, let's see. Baltimore removed a statue of Roger Taney. Was this right, wrong, appropriate? Anyone? I'll venture on that one. I'd be happy to take it down, so I don't see any problems with that. So, I mean, you have to think, and we memorialize people for their contributions to the nation, and I don't see as Roger Taney as contributing
Well,
much
look-
positive to the nation.
Look at Lee. Look at Lee. You know, to take that, really make a turning if we the taking down of that statute finally is a confirmation that the South had it wrong in the Civil War. I remember Grant in his memoirs saying, meeting Lee and saying at Appomattox and saying how sad it was to see such a valiant commander brought to this position. And then he says, but I have to say, he expended his valor and his arts in the service of the worst cause imaginable. You say, well, okay, at a certain point, is that what we're seeing? Is that what we're finally seeing? If so, it's not something to be deplored.
Other thoughts, gentlemen?
Wasn't a bust of Tawney just removed from the Congress in the last year? In the Capitol? Wasn't it removed from the Capitol in the last year?
I don't know. Does anyone know?
I recall
Oh, no.
reading something like that. Yeah, I think from the Capitol.
I have a funny thought. The first part of the funny thought agrees with everybody on the ground that each generation gets to decide who it wants to memorialize. I have a bit of an historical sensibility. I travel throughout Europe, throughout the country, and there's one statue to an anti-Semite after another. The best we can say is we've taken the statue of the Nazis down, but not the people with the pogroms and everything else that did their best to prevent me from being here today. And I always just read them as this is what people in the past respected. And the statute reminds me that these were our past values without dictating what are the future values. But if my fellow citizens disagree, unlike, say, President Trump, I don't think, one, there is any obligation to the past to keep the statute out. And I certainly don't think Robert E. Lee is a hero that we should commemorate, that once the statute is understood as honoring the person and not simply as an historical relic, it goes down.
You know, I share some of Mark's views on this point. Yeah, nevertheless, at a certain point, you raise the question: the ones we memorialize, are we memorializing because they're people of that era? They were really reflective of the 1920s, or are we memorializing and putting them up for a place of honor because there is something about them, about the principles they represented, that doesn't need something that commands our enduring respect? That's another construction of what we made here. But may I say also, before I leave, that if Mark Graber weren't there, I'd have to have somebody else invent him.
Well, that's a good note to end this. Thank you, Mark Graber, David Tubbs, Hadley Arkes. It's wonderful to see you. And thank you to the National Association of Scholars for hosting this event. Go to the NAS website for future events like this. And thanks, everyone, for joining us.
Thank everyone.
All right,
Thank you.
good day.
Good to see you,
Thank
Mark.
you all.
Great
Bye.
to see you guys.
Good to see you, Hadley.
Great, David.
Nice to meet you, Mark.